Welcome. Thank you for joining us. This is the Boise Metro Chamber's Metro Minute Series, your quick guide to business impact. I'm Tori Thomas, Community and Government Affairs Manager here at the Chamber, and your host for today's event. The Boise Metro Chamber is Idaho's only 5-star accredited chamber and represents nearly 2,000 members. We are only able to provide current events and educational content because of our members and their investment in our community. Before I introduce our speakers for today, I want to thank Hawley Troxell for their generous support. Please enjoy this quick video from our sponsor.
We date our roots back to the 1860s with James Hawley. Although we have a long history, we've also done well to adapt to the future and adapt to what it means to provide legal services today in what is often a high-tech world.
When you have 110 lawyers under one roof practicing together, they help each other out. It's a great value to the client.
The values we're presenting to our clients and to each other, and the way we're conducting ourselves both professionally and personally makes it a natural fit that we're going to do our best to serve the members of our community.
Well, for today's episode, we are joined by Wolff and Josh Scholer. Hey guys, thanks so much for joining us today.
Hi, Tori. Thanks for having us.
Yeah, of course. We'll do a couple quick bios for people that get to know you guys, and then we'll get going. Wolff is the administrator of the Division of Financial Management. She previously served as the administrator for the Division of Human Resources. She has served as interim director at the Governor's Office of Energy and Mineral Resources and the Idaho Department of Administration. She also previously worked at the Idaho Department of Health and Welfare, serving as deputy director and division administrator, among other positions. Wolff is a lifelong Idahoan who was born and raised in Salmon, Idaho, and graduated from Idaho State University with a master's degree in public administration. Josh was born and raised in Boise, Idaho, after receiving his undergraduate degree from Boise State University and completing law school at the University of Idaho. Josh began working in his current role in the executive office of the governor. Josh serves as legal counsel to the Division of Financial Management and is one of 3 lawyers who serves as counsel to Governor Little. Josh specializes in administrative and constitutional law and oversees all of Idaho's regulatory landscape, vetting each and every single proposed agency rule, as well as overseeing the ongoing update and rewrite of Idaho's entire administrative code. So thank you guys so much for being here today. We appreciate all you do in the community, and we're excited to chat about this topic.
Excellent.
Alrighty, so today's fun topic, let's get into some questions and chat about Chevron Deference. First, I would love for you guys to just kind of break down what that is and how it did impact the relationship between federal agencies and the courts.
Great. Well, I'll kick it off, but obviously the attorney in the room is going to be able to do a lot more in depth on kind of the impact of that court case. But I want to start just by, why do we care about Chevron deference? And from a business perspective, why would you even ask the question about Chevron deference? So obviously I've been in state government for a long time. Sometimes I forget how many agencies I've actually been in, but the way it works when we, as agency directors, or as we're working within agencies, we have statutes that give us the statutory authority to, administer the programs that we have. So whether it was when I was at Health and Welfare, we had a food stamp program and a Medicaid program, and statutorily, it's set up to be able to have the program. But then the agency comes in and writes administrative rules for the specifics about how they're going to administer it and how they're going to apply that statute in the decisions that they make, whether it's eligibility decisions or whether it's regulatory decisions. So I would say of our 60 to 65 state agencies, all of them have rulemaking authority. And Josh's team, we're all part of the governor's budget and regulatory office, combs through those regulations every single year. Agencies are consistently updating their rules and proposing new rules, cutting out rules. So the reason we care about Chevron, and Josh can get into exactly what that means, is when a third party or a private business or an individual wants to challenge how an agency has applied the administrative rule that's been approved by the legislature, and they may take that to court, the Chevron deference started with explaining how they would defer to state agencies. And that's what's really important in these cases. And we're going to go through what Chevron is and then why it was overturned. But it really does speak to what authority the agencies have in being able to both apply and interpret their rules, regardless of the ambiguity of that. So I'm going to let Josh get into kind of the specifics of what Chevron did, and also what the court case that overturned it, how that kind of flipped the script on that. So turn it over to you, Josh.
I have to say, when Lori asked me to do this, I was quite thrilled. As I've told you both, this is my favorite area of law, which I think that makes me 0.001% of lawyers in Idaho who's probably this is their favorite area of law. So, but I do think it's something that when you talk about with people, just the ramifications of what this actually is and what this meant. It starts to, I mean, even as you and I were talking yesterday, Tori, like as you said, you started to dig into it, and it really starts to actually kind of hit home. And so when we talk about Chevron, when you like scale back for a second and you think about two individuals or two parties in court, normally you start and you go in front of a judge and you make your arguments, right? And in theory, right, that it's whoever has the best arguments whoever the judge agrees with is gonna rule the day. In 1984, the United States Supreme Court took up a case called Chevron v. Natural Resource Defense Council, and I won't get into the details in terms of what that case was about, but it has to do with an environmental regulation, and there was a dispute about, and there was an ambiguity in the statute about what exactly certain statutory phrases meant, and there were some rules that the EPA had, or that the federal agency had promulgated to that effect, and they were challenged. And the court basically said, they laid out a two-part test that said, first we have to ask as a court whether or not Congress has spoken clearly to the issue. And if they said that this means this, then that's where we'll stop and we'll just apply what Congress wrote. But if not, then courts are required to defer to an agency's interpretation of statute. And it doesn't have to be the most reasonable. It doesn't have to be the best interpretation. It's just as long as that the agency's interpretation is a permissible construction of the statute. And so that kind of, when you think back to what I just said about normal two private parties coming into the courtroom, it's not necessary. No one gets that deference ordinarily, right? It's not, usually it's pretty even, but now if we have an ambiguity, which they tell us in law school, your ambiguity depends on your judge, right? At the end of the day, if you have that ambiguity and you have that deference to an agency, suddenly there's automatically this very big power imbalance. And so under Chevron, the courts were required. Once that ambiguity was found, that deference had to kick in. And then, of course, we fast forward, and I just really quick want to touch on, I found this, there's a CRS report, the Congressional Research Report, that studied Chevron cases in the federal courts of appeals, and they found that agencies won almost 94%. Once you got to that step 2, right? Like anytime there was agency deference, I mean, it is nearly an automatic win. Like, this is not you give us your arguments and we'll go from here, right? It's if you get to, then it's a win. And so this is really something that there's been thousands of cases in terms of the federal courts that have used this over the years and just kind of applied this deference. And so I wanted to point that out, just say that this isn't some random phenomenon that doesn't, get played out very often. This is something that's been used a lot. And then coming onto the stage this year was the case Loper Bright Enterprises v. Raimondo. And this was something that has been brewing for a long time. They've been kind of cutting away at Chevron slowly but surely. The Supreme Court has. They note that they haven't used it since 2016 to decide a case. They're the exception, I would say, instead of the normal rule. And so they came forward and said, well, it's time to revisit this. And they overruled Chevron, and in its entirety, it had already been kind of hanging out there as what's referred to by some of us legal nerds as like zombie precedent, right? It kind of is still there, but isn't really having much force and effect. And at the end of the day, Justice, the Chief writes that the court's job is to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and that a court may not. And so not even may, but doesn't have to, but may not defer to an agency interpretation of law simply because the statute is ambiguous, right? At the end of the day, you're the judge, and you have to be the judge, and you can't, it may take some more work, but at the end of the day, you can't just say, all right, well, we'll defer to you because I'm not sure what this means. And so that's where we're at with, if you have an Idaho business that ends up in federal court against a federal agency or anything like that, now that is no longer the case that when there is an ambiguity, that an agency gets any amount of deference at all.
Thank you both for that explanation. Really interesting. I think I'm so glad that you were excited to join us, Josh, and that you're so in depth in all of this. I think it's so interesting. And I know I mentioned to you yesterday, I guess my first thought was like, oh, it seems like agencies might have like the inside scoop on what should be done. But then reading more about it and realizing that that's not really how our government works, it really makes sense that we should be overturning this, and that obviously we did, and that's cool. That's where we're at now. So keeping with that process, either one of you, can you talk about the two-step process involving or in applying the Chevron deference?
Yeah, so that was what I just saw. I got so excited about it that I just kind of just went through, right? It's that first you have to ask, has Congress spoken to it, right? Does the federal statute say whether or not, does it address the issue? Can you do X or Y? If it has, then the court just says, I'm going to apply it. And if they don't, if it doesn't say that, then step two is if there's an ambiguity, then the courts would have to defer to the agency's interpretation. And I want to just reiterate, it didn't have to be the best. It didn't have to be the most well thought through. It just had to be a reasonable, which of course it's one of us lawyers' favorite words, right? Is reasonable. It just had to be a reasonable or a permissible construction of the statute. And then at that point, there's agency deference, and that's what carries the day.
Cool. Okay. Well, clearly you know so much. I was like, I think he talked about the process, but I want to make sure.
No, that's my fault. I can talk about this stuff for hours. So yeah, I just got ahead of you.
No, it was perfect. I appreciated it. Okay. So then I know we kind of touched on the branches and the government setup that we have. Can you chat a little bit more about how deference did affect the balance of power between executive, legislative, and judicial branches?
Yeah, and I can speak to that a little bit. I mean, obviously, Josh has a legal perspective, but I think this year, and we're going to talk in a little bit about, some of the things that are happening at the state level. But I think this was a huge shift, in the past when Chevron was applied, and to Josh's point about, 94% of the time they're going with the agency interpretation. I think it put a lot of power in the agencies, and maybe also took away some of our responsibility to make sure that our rulemaking was clear and aligned directly with statute. I mean, I don't want to say we were sloppy, but I think even in this case on the federal level, and reviewing a lot of those administrative rules that would come down from federal agencies, there were a lot of holes in it. And there were a lot of things, even from a state's perspective, that were difficult to interpret. So I think what this overturning the Chevron deference did is swing that balance of power and really said, it took it away from the agencies and basically put agencies on notice and put a lot more power in the courts to be able to say, look, I'm going to look at this just very clearly and objectively, and we're going to apply the standard when we look at statute, when we look at rulemaking, and we're going to give our best interpretation. And I think the word Josh used in the actual decision that was written is they get to use their independent judgment. So they don't have to defer to, well, this is what we meant it to say, or this is how we meant it to work. So I think that's the shift that you saw. And we're starting to see that on the state level as well.
Yeah, and Tori, I would just say that, think back to when I talk about this with, folks for the first time, I say, think back to your senior, junior year government class, right? When you learn about the three branches of government and what they do, right? You have the legislature who creates the laws, you have the executive branch who executes the laws that are written, and then you have the judiciary whose sole job is to interpret the laws and say what they mean, right? They are the arbiter at the end of the day. And so when Chevron was a thing, when it was the law of the land, so to speak, it essentially took your power from the judicial branch. And even if they would have come to a different result, they weren't able to, right? Your district courts, your courts of appeals, they couldn't do it. And so now, the main argument is that now we've, like Lori mentioned, we've returned to this balance where at the end of the day, the legislature writes what the laws are. And of course, as long as we have unclear statutes and, we will always have, especially in Idaho, right, where we have a quarter time, say part-time, but they're here for 3 months out of the year, right? They rely on agencies to help fill in those gaps with their expertise. And then now it's then when there's a dispute, the court gets to come in and say, well, I'm reading this statute and your rule does not comport with that statute, or it does. But at the end of the day, you actually have to put in the work. And the judiciary has one job to do, and that's interpret the law. And so that's the balance that has been shifted back, I would argue, to the right spot, and there's more of a balance there.
Awesome. Thanks. I think too, if you give the agencies the power to do that, it seems subjective. Like it seems like they might not have the best interest, not necessarily they're like trying to have bad interest on people, but I think it could, sorry, I'm losing words, but I think obviously our judicial branch is there to interpret it. And then if you allow agencies to do it, they might not have the best interest at heart. And maybe just because they don't have the experience or even the knowledge and the power to do so. So, well, talking about the Chevron deference, obviously, can you guys share an example of an Idaho equivalent version of this?
Yeah, and it's actually really interesting timing-wise how this is playing out with some of the things that we're going to talk about in the overturning of Chevron this year. So again, I'll let Josh get into the details, but I think to your point, Tori, we're seeing some of the shift, I think, just naturally in the landscape around making sure that we have more of that objective view of, how regulations and how rules are being applied by agencies. Coming from an agency, I do think, we get mired into the work. And I do think, agencies really do try their best to make sure that they're implementing those the way they need to. And, from a government perspective, all rulemaking is reviewed and approved by the governor. And then in Idaho, it must be passed by the legislature in committee and signed off in both houses. So there is a process to make sure that we're navigating these administrative rules. And I think, agencies are kind of entrusted with, this is how we're going to implement these programs or apply these regulations. So the challenge is, I think it's the objectivity or the subjectivity. I think sometimes agencies come with a subjective view of, well, this is how we do it, and this is how we've always done it, or this is how we're interpreting it. So we definitely have a different perspective in applying those. So Josh is going to talk about the case that was actually a decision by the Idaho Supreme Court. And then we'll also talk about just this last legislative session, well, actually before, a House bill that passed the Idaho legislature that kind of did the exact same thing and flipping that that agency deference. So I'm going to go ahead and let Josh kind of walk through what the Simplot case was and what the House Bill 626 did.
So yeah, so the Simplot deference that Lori's talking about is a case from 1991, and that's the J.R. Simplot Company versus the State Tax Commission. And very basically, that case was about whether or not taxable income, the definition of taxable income, whether or not that included foreign sourced income. And so there was a dispute there, obviously, between Simplot and the State Tax Commission. And in that case, so we have Chevron, which has kind of a two-step process. And then we have this Simplot deference, which I would say the main difference between Chevron and Simplot was that Chevron was mandatory for courts once you got to that second step. And then, but Simplot is more of like it's a 4-factor kind of analysis that a court has to engage in. And that's, I'll list them out real quick. The first one is whether or not the agency is actually entrusted by the Idaho legislature to administer the statute, whether or not the agency's construction is here we are again, reasonable, right? And then whether or not the statute actually already speaks to the question at issue. And then this more vague, whether the underlying rationales for deference are present, right? So then that's more of like it's a pretty easy, by and large, test to hit if you're an agency. And so, there's been several times since this case where there's, in fact, 2 tax commission cases, at least that I found, where they did defer to the tax commission's interpretation. So it has been used, not nearly as much as Chevron was at a federal level. But so that's kind of the 4. And the weird thing about the Simplot one deference is that even if you have 3 out of the 4, the Idaho Supreme Court said, well, even if you're missing 1 or 2, courts should engage in a balancing, whatever that meant, right? Because at the end of the day, maybe one of those things matters more or is more important than the rest in this particular case. And so from a person challenging an agency action perspective, right, I don't really have any sort of guarantee, or like, I don't know when I'm going to be able to make my arguments, when I'm going to know that I've beat this test, right? Because even if I beat 2 of them, maybe the other 2 win the day still. And so then fast forward from 1991 to last session, House Bill 626 was passed, and it changed the Administrative Procedures Act, which governs rulemaking and things like that, to say that whenever a court is reviewing or considering essentially the meaning of any statute, any agency rule, they cannot defer, and they have to do they have to interpret the statute or rule de novo, which is just we lawyers love our Latin phrases, and that's just it's called free review, and that's just as if it has never been looked at or interpreted before by anyone else. And so, and it also says that they have to review it de novo, and they cannot defer to an agency in their interpretation. And then the latter part of the statute change said that after a court has applied all their normal tools, right? That courts have tools to interpret statutes. And after they've used all the tools in their toolbox, if there's still any ambiguity or a question about what something means, the statute says that, they have to exercise, a reasonable conclusion that advances individual liberty and limits agency power. Now, that's fairly ambiguous, like, to be fair. What we've interpreted that as is basically tie goes to the individual, and the tie goes to the person that's challenging an agency action. And so Simplot deference was around for, I'm a lawyer, so I don't trust my math, but 33 years, right? Something like that. And so, but as of July 1st of this last year, the Idaho law is that courts have to interpret it de novo and can't defer to an agency interpretation.
Got it. Okay. And then what would the argument be for and against courts deferring to agencies?
Well, I think, I'm going to take this at kind of a high level because I know we're getting close on time too. But I mean, I think the argument that was made when these court cases originally came forward was, the agencies have the background, they understand what they intended, they're more informed about the statute and the programs, and they come to the table, I think, more knowledgeable. I think, again, we talked about the subjectivity that interpretation also brings. So I think the law that we saw passed and also the overturning of the Chevron Deference this year shows that, we want to make sure that we're balancing that power, and that governments, I think the message is that we hold government agencies accountable to the people and to legislative intent. And I'll just give a little plug for Governor Little and why, we're very supportive of this direction. Idaho's the least regulated state in the country. He's been working hard to eliminate unnecessary or over-regulated administrative rules, and kind of does the same thing that I think this bill did, which his angle is we support individual liberty, and we want to also support accountable and transparent government. And I think that's what both this court case and this new statute has done, is putting us on better footing for business community, for individuals, and really kind of setting the table for this is what you can expect from your government, and we're going to hold ourselves accountable, and we're going to be very transparent and about how we implement these programs or how we implement regulations, and deferring to that individual liberty.
We can't hear you, Josh. I don't know if it doesn't look like you're muted though. Oh. Okay, well, you don't get to talk for a second, I guess.
Yeah, we can't hear you.
Yeah, you're done. Just kidding. Lori, I love that answer. I do agree. Obviously, there's so much knowledge within all of these agencies, and it would make perfect sense that they would have this opportunity to do that. But then I also agree that there should be accountability on our government. If we have it set up the way that we do, they should have to have that accountability. And the agencies can keep, doing great things for our community and, being a part of these conversations, obviously, but maybe beforehand, when you're discussing legislation or rulemaking. But at the end of the day, yeah, it should come back down to our government. So, and we always love plugs for Governor Little. We're big fans. Well, I hope that we can get Josh back. I just want to ask maybe one more question, kind of about how agency deference might affect Idaho businesses. So particularly within ag or in energy and technology.
Yeah, I can take a crack at that. Josh might have a legal perspective on that, but I think both, particularly Idaho businesses, I think, since we saw this swing at both the federal and the state level, I think, from their perspective, reviewing those regulations, making sure that there's not ambiguity. I mean, I don't want to say you can take them to court and win. That's not what we want. But I do think, there's a higher standard now for both the federal and state governments to be able to be very clear about the regulations and how those apply. And I think private businesses need to know that, now they're sitting in a seat where, their interests are going to be better protected. And I think they have, a more equal voice at the table. And when Josh started that, if they are in court or if there is a dispute, I think the voices and perspective are weighted more equally now. And I think that's important for private businesses to know, and that their government will be held more accountable.
Oh, can't hear you.
Darn, Josh always has the good stuff too.
I know. Might have to do a follow-up. Well, yeah, can't hear you. I know. Dang it. All right, you're done.
Right.
Apparently. Oh,
Wait,
now
we can hear now. I don't have a good answer for you.
okay.
No, I would just echo what Lori said. I think, we have a lot of agencies. We have, in fact, one of our agencies is running a huge, massive behemoth bill this year that is moving a lot of their rules into statute now. And because a lot of those rules are interpreting statutes. And so I think we have some, it's going to be certainly a different dynamic now where agencies, when they're doing rulemaking, I've seen it a lot already just in a few short months, where they have to be very precise and they have to be very, right. You can't just rewrite the law however you want. You have to make sure that you're being as precise and as within the bounds of the law as possible. And it's going to be growing pains, absolutely. But I think ultimately for the better at the end of the day.
Awesome. Well, thank you guys so much for joining us and discussing this. I obviously learned a lot and am still learning. So hopefully our viewers feel the same way, but we appreciate all the work that you do for our community and for our state overall. And hopefully we get the chance to chat again soon. Really appreciate you guys being here.
Thanks for having us, Tori. It was fun.
Yeah. Thank you, Tori.
Yeah, of course.
Blast. Thank you.
Yeah, definitely. A huge thank you to our sponsor, Hawley Troxell, along with our media partners, Idaho Ed News, Idaho Capital Sun, and Idaho Press. Thank you for watching, and we'll catch you on the next Metro Minute.